It is the final session of our conference. It is again my honor to quickly, because we're as always running late, to quickly introduce our chairperson. So we are lucky and happy indeed to have Jason Harris amongst us. He teaches at the University of Sydney as a corporate lawyer, and he has such an impressive, I've had a printout of all your academic achievements, of which to me stands out that you seem to keep close track also of practical developments inside the law. So it's this epitome of combining practical and theoretical perspectives on the law, more precisely on our beloved corporate law. And again, I think you're just in a perfect position to preside, and I'm excited to hear from you and from your presenters. Thank you.
Wonderful. Thanks so much, Chris. And thank you to the Centre for inviting me over to chair this session. It's been a really fascinating day, and I'm looking forward to our panel. So I'll introduce our speakers. So our first speaker is Professor Eva Micheler, who's a professor at London School of Economics, teaching corporate law and the law of corporate finance. And her most recent book is Company Law, A Real Entity Theory from 2021. We also have Professor Antigone Alexandropoulou, who's the Deputy Dean and Associate Professor in Corporate Law at the European University Cyprus School of Law. She's written multiple books on company law in Greek, in German, and in English. So welcome. And our third speaker is Professor Kerem Selikboya, who teaches at Istanbul Bilgi University, where he teaches corporate law and business law. So without further ado, I'll hand over to Eva.
So good afternoon. Thank you very much for the kind invitation to speak here about directors or legal person as directors in the UK. And I'm going to hark back to this morning when we were reminded that American corporate law derives its origins from public law. The corporation initially there was a public administrative unit administering under a monopoly a certain geographical area. And indeed, these roots are present in all of the European jurisdictions that I'm aware of. They are not present in the UK. The UK did not develop from that public law model, and that is really because of a historic accident. And the accident was the South Sea Bubble, which was ended through the South Sea Bubble Act of 1720. And then for almost 150 years, incorporation was impossible. And that led to a private law development. And Erich earlier asked this question, why do we talk about corporate law in the United States, in also places such as Australia, by the way, and not in the United Kingdom? In the United Kingdom, company law derives its origins and its roots from partnership law. So for about 150 years, pure private law, partnership law combined with trust law was used to build companies. And from that perspective, the general starting point is one of anything is possible. Because what we're doing is we're making contracts. We're making arrangements of private law. So therefore, of course, the starting point is you can have a corporation or a company as a director of another company. So this is a beautiful test case for ideas about using companies to be directors of other companies. So what I'm going to do is I've got three aims. I'm going to tell you very briefly something about the terminology I use. I will then talk about analyzing UK law, and then I'm going to sound a note of caution. So incorporated directors is the term I use, and I think Loris uses the same term of a situation where a company or a corporation is appointed as the director of another company. So the law in the UK before 2006 was liberal. So it was possible for a company, a foreign company, any company to be appointed a director of another company. The explanation is the historic contract law explanation. The modern explanation is whatever the shareholders like goes. And there are legitimate use cases. So Loris mentioned the case of inner group structure. Todd this morning had a hypothetical legitimate use case. He said a bit more than saying a director is appointed a director of another company. He had some assumptions and predictions. So the idea he had was, if this was possible, what could happen is a market where corporations offer a service of acting as directors for other corporations. And that would be, so that's the assumption that there would be a market. And there's a business model for this because otherwise there is no market. And the assumption was that that would result in better governance. And the UK is a good case to test this. And I can tell you now that doesn't happen and didn't happen in the UK. What happened was, are a number of, so what has happened and continues to happen is the ability of shareholders to appoint another company as a director adds to the repertoire of people who want to hide illicit activity. I'm going to do two examples, tax and of course, money laundering. Now, let's look at this. Since 2006 then, in response, there is a rule that one director, and Loris mentioned this earlier, has to be a natural person. And there is now another reform proposal waiting in the wings, where the final reform package was started then 2 years ago. But of course, we've had quite a political turmoil and the reform has yet to be implemented. So that's in broad brush, the rule in the UK. Now, my note of caution then. I think what we need to do is, if we want to do something new, we have to carry out a cost-benefit analysis. So what needs to happen is we need to say, what are the advantages? And I'm fully expecting potential and hypothetical advantages to be part of that. And the two advantages of sort of a directorial, professional, competitive service is one of them. Legitimate group structures would be another. And we need to contrast that with the disadvantages and then take a view on what we would like. So I don't think anybody should rush without analyzing cost and benefits to carry out reform on anything. Okay, so note of caution. Let's look at the situation. So I'm not talking about a case called paycheck services. Paycheck, of course, is the word, ancient word. Nobody gets a paycheck anymore. We get money on our bank accounts. But paycheck services was a service provided for administering billing services. And paycheck services is the case of a tax abuse or a tax evasion scheme that I'm going to look at. So before 1999, a married couple, Mr. and Mrs. Holland, provided through paycheck services, administrative services to, so this company was owned by them, and there were some clients and some contractors. The contractors were people that worked in IT services. They were programmers and provided other services to the clients. So here we go, services provided. And if you're a contractor, your biggest headache is not the programming, but then billing your clients, chasing the money, paying your taxes. Okay, anybody who's ever had to do that, it's really tedious work. So contractors hired the Holland people through paycheck services, and they were employees of paycheck services. You will immediately slightly smell the rat at minimum wage. So they were employed by Paycheck Services, but they were also a shareholder of Paycheck Services. So the way this worked was that the clients pay Paycheck Services. Paycheck Services then pay the employment component of the remuneration, and they pay the tax for employment and the national insurance contributions for employment. And then the rest of the money is paid, so that's the payment of the employment, and then the rest is paid to the contractors in form of a dividend. That component of the scheme was actually fine. HMRC wasn't unhappy about that. There was enough independence in the arrangement that they didn't worry about that. The problem arose because Paycheck Services started being very successful and all of a sudden was paying corporation tax initially as a small business. But then as they became more successful, the threshold for a small business was 300,000. They went over the threshold and would have had to pay more corporation tax. Super unappealing. The difference was, I think, almost 15 percentage point more of corporation tax. So then advisors were brought on and the paycheck empire was constructed. And here is how it worked. So we've got our clients, we've got the contractors, and then we've got the Hollands. So far, all clear. And now the services are provided by the contractor. So they keep programming and providing IT advice. And Mr. and Mrs. Holland continue to have Paycheck Services, of which they're owners and directors. Paycheck Services then, and here we go, incorporates two subsidiaries, and these are secretarial and directors. Secretarial, interesting, is actually a provider of directorial administrative services. Okay, so what they do is they help directors to do the administration required to be a company director, so dealing with company's house, looking after corporate governance, and they are a profession that is associated with the accounting profession. We're not interested in them, we're interested in directors, limited. So next thing, Mr. and Mrs. Holland were directors of both Secretarial and Directors Limited. So that was their involvement. And then there was 42 companies, Paycheck Services 3 to Paycheck Services, 42 plus 3, so 45. And the contractors were employed by one of them and held shares in, again, at minimum wage, and held shares in each of them. So what they did was they cycled through them one by one. As soon as one of them reached the 300,000 threshold, they moved on to the next. So that none of them went over the small business threshold. And they were independent companies. So who were they owned by? They were owned by, so this is the relationship of them being directors and secretary of the paycheck companies. They were owned by Trustees Limited. So Trustees Limited was the voting shareholder of Paycheck Services, and the contractors had non-voting shares in each of them. Okay, so the 42 companies had as owners a trustee company, and then as non-voting owners, each of the contractors, and they had each a separate class of shares. So what could happen if contractor 1 served a client, then their payment was processed to their separate class of shares. So dividends could be paid individually to the respective directors. And then Mr. and Mrs. Holland held shares in trustees, and Mr. Holland originally held that voting share in these companies and then held them, transferred them on to Trustees Limited. Okay, you can see it's a completely difficult and very complicated corporate structure. The sole purpose of it was to not pay corporation tax at the rate for a large business. And then, of course, the payments were the same. The clients pay the 42 companies, the 42 companies pay the contractors. Now, HMRC took a while to work out what's wrong with this. And they were suspicious very early on, but they had to pin this to, in some way, that this is one whole structure, that they work in concert in some way, shape, or form. And then the legal formal argument that nailed it was that Mr. Holland was originally the settlor of that trust. So that was the pin where they said, so this is a structure, it's a whole structure because there's one person delivering it. So that ended the scheme, but the case arose because the question was, is Mr. Holland a shadow director? So this is what we heard earlier. Do the shadow directors, or actually maybe is he a de facto director, so he's personally liable for the negligence in setting up a tax evasion scheme? Now, the case ended with the majority of the House of Lords concluding, so that's the Supreme Court, the House of Lords concluding that Mr. Holland wasn't a de facto director because all he did was he was a director of the director. And that's not good enough. There was a very powerful dissent saying this is arid formalism, but that's just the dissent. I don't think there's anything legitimate in that structure. I told you there may be a labor law angle that's complicated. And there's also, I think, a very important question there. This structure made it very difficult for HMRC to investigate this. It's extremely costly investigation if you've got several companies working out who they are. And we don't even have here an external angle outside of the UK. Okay, the next one is the US Crimes and Enforcement Network, where the following thing happened. Between 1999 and 2017, they found 3,267 UK limited liability partnerships, that's a form of company, and liability partnerships, that's the equivalent of the liability partnerships that you're all familiar with. And they were registered in the UK during that time, had no legitimate business. And they were set up for illicit purposes. The suspicion is money laundering by UK registration agents. And that case was cited by the government when they discussed and analyzed the most recent reforms. The ownership in that company, in these companies, was hidden in secrecy jurisdictions. That's a technical term for jurisdictions where ownership in companies isn't publicly revealed. So these are third countries where we cannot find out who owns a company. At that point, of course, there's nothing you can do because you just don't know who owns this vehicle, and that's the end of your investigation. So reforms then. So since 2006, we've already heard all directors must be natural. So the reforms proposal, since 2006, we've heard every company must have at least one natural person as its director. The reform proposal is for all directors must be natural persons with verified identities, with one exception. And this is an exception that has been going back and forth between the legal profession and the government, because the legal profession says there are legitimate use cases. And one of them is, of course, group structures. We can also see a situation where we've got some trust structures, and so you can sort of, the government is, of course, keen to not thwart business completely. So the exception that they came up with is only entities with legal personality can be a corporate director. And they can only be entities which have only natural persons with verified identities as their directors. So you can have an incorporated director, but only if that incorporated director itself has only verified natural persons as directors, and they must be registered in the UK. So that's a significant step back. These reforms haven't been implemented. The reason is that the UK has been very busy with all sorts of things that they've been doing. For example, leaving the EU, and then there was a pandemic and all sorts of very turbulent times in government. The reform is still on the books right now. I think it's a bad time for anything that thwarts business, because the government is really trying to promote growth. But I think what it will take is just another tax scandal or money laundering scandal for them to open the books again. I think the times when I was first starting out, avoiding tax in Austria was a national sport. So this was something that everybody did. I think the world has changed very much. I heard yesterday from Rolf, I don't think he's here anymore, but Switzerland now doesn't accept money that's untaxed. Neither does Liechtenstein, so that things have changed significantly. Okay, so then my note of caution is the idea of having a liberal approach is a really good one. I would, however, urge anyone who embarks on this, especially as far as hypothetical use cases are concerned, to carry out a cost-benefit analysis before they do and decide whether, on balance, the problems that they buy are worth the advantages that are promised. So on the whole, I think a note of caution is required. And that's me on what's going on in the UK. Thank you very much.